California has long operated under the delusion that state and local governments can simply ignore the U.S. Constitution. But this is not just about ignoring the law. This is about enacting a calculated, malicious strategy to strip fundamental rights. The recent move by the Department of Justice Civil Rights Division, headed by Assistant Attorney General Harmeet Dhillon, filing the first affirmative lawsuit in support of gun owners against the Los Angeles County Sheriff's Department, the LASD, isn't just major news. It is confirmation that the weaponization of bureaucracy against the Second Amendment has reached a fever pitch, resulting in thousands of law-abiding citizens being intentionally disarmed. This isn't bureaucratic inefficiency. It is a clear, systematic obstruction of constitutional rights. We are finally seeing the federal government step up to fight back against the systematic infringements that are making the right to bear arms meaningless in practice. Hey, legal eagles, let's dive into the specifics of this monumental lawsuit, because the numbers laid out by the DOJ are genuinely staggering, and they form the factual predicate necessary for a successful civil rights action. This legal filing, brought in the Central District of California, targets the LASD and Sheriff Robert Luna for what the complaint describes as a deliberate pattern of unconscionable delay. This is the central legal mechanism of the infringement. The authorities aren't denying permits through outright refusal, which would immediately trigger obvious appellate remedies, but instead they delay the processing to the point where the constitutional right itself is effectively rendered meaningless in practice. The sheer statistical absurdity confirms this deliberate intent. The DOJ's investigation analyzed data and documents spanning over 8,000 CCW permit applications. The critical time frame focuses on new applications received between January 2024 and March 2025. During that time, out of 3,982 applications for new licenses, the LASD approved exactly 2. I want you to internalize that percentage, a truly dismal 0.05% approval rate for new applicants. You simply cannot rationally explain such a microscopic rate purely through legitimate disqualifying factors or even simple staffing shortages. It is mathematical and empirical proof of systematic obstruction of constitutional rights. The delay metrics detailed in the complaint are equally damning. The typical applicant was forced to endure a median delay of 372 days, far exceeding a full year, before receiving a final decision. Crucially, the LASD forces applicants to wait an average of 281 days, more than 9 months, just to begin processing their application. Some law-abiding citizens face delays as long as 1,030 days, or nearly 3 years. These timelines flagrantly disregard state law, as California's own statutory requirement dictates that licensing authorities must provide initial determinations within 90 days. This flagrant disregard for both state law and constitutional obligations demonstrates this is a delay-in tactic. The constitutional violation here is described as staggering, leading thousands of law-abiding citizens to simply give up and withdraw their applications out of frustration. This is how a right is starved to death, not by a ban, but by endless bureaucratic strangulation. This lawsuit is a direct legal and ideological response to the post-Bruen environment. Before the Supreme Court's monumental 2022 decision in NSRPA v. Bruen, jurisdictions like Los Angeles were effectively may issue, meaning local authorities could demand that applicants show good cause for why they needed a CCW permit. Bruen categorically ended that discretionary requirement, mandating that the right to bear arms outside the home must be treated like any other fundamental right. However, the political apparatus in California, a state infamous for layering on restrictive gun laws, did not simply comply. Instead, many agencies, including the LASD, appear to have pivoted, weaponizing the remaining procedural hurdles, namely the requirement for good moral character and the permitting timeline itself to achieve the same restrictive outcome. As Assistant Attorney General Harmeet Dhillon put it succinctly, the Second Amendment is not a second-class right. This is the core legal principle at stake. When one is required to petition the government, pay multiple fees, submit to extensive training, and potentially undergo a psychological evaluation, all while waiting years for a decision, that constitutional right has been undeniably relegated to a mere privilege. The investigation was formally initiated by the DOJ Civil Rights Division on March 27, 2025, following numerous complaints indicating these inexplicable delays violated the U.S. Supreme Court's interpretation of the rights of law-abiding citizens. The data supports the conclusion that LASD was systematically circumventing the spirit of Bruen. As of May 2025, approximately 2,768 applications for new licenses remained pending, with interviews scheduled out to November 2026. When the median delay for an application is 372 days, and the permit itself is only valid for 2 years, the permit process is not functioning as a regulatory safeguard. It is operating as an effective de facto denial system. This is a prime example of administrative activism, attempting to nullify through bureaucratic obstruction what they cannot deny through law. The DOJ is drawing a line in the sand, demanding that rights, whether they are exercised under the First Amendment or the Second Amendment, must be treated equally. When a government agency is accused of such profound constitutional violations, they invariably resort to claiming logistical impotence rather than malevolent intent. Let's analyze the counterarguments presented by the Los Angeles County Sheriff's Department. The LASD claims they respect the Second Amendment and insist that they are committed to addressing all applications fairly, promptly, and with a balanced approach. The department attributes the widespread delays to several major structural problems. First, they claim the current sheriff, who took office in December 2022, inherited a dysfunctional system. Second, they point to the massive surge in applications following the Bruen decision, which created a backlog that peaked at around 10,000 applications, although they claim this has been reduced to about 3,200. Third, and perhaps most centrally, they cite a severe staffing crisis, noting that they currently have only 13 personnel assigned to handle the entire CCW unit, a unit that serves a county of over 10 million people. The process was further complicated by a transition from an outdated paper-based system to a more streamlined online platform, which was underway during the DOJ's investigation. The LASD attempts to mitigate the stark statistics by providing alternative numbers, stating they have processed and approved more than 19,000 concealed carry permits since 2020, and specifically issued over 5,000 permits in 2025. They argue this improved issuance rate is proof that they are not engaging in a pattern or practice of depriving individuals of their rights. However, these defenses crumble under the weight of the central accusation. While they claim improved issuance rates, the DOJ data specifically targets the crippling delays faced by new applicants in the 2024-2025 period, confirming that the approval rate for these citizens was virtually zero. If the lack of personnel is the bottleneck, as Harmeet Dhillon argued, the solution is straightforward. They need to just hire more people to do this. The fact that cities like Washington, D.C. can process permits in 6 days demonstrates that an efficient, timely process, one taking a couple of days or a week to ensure the applicant is not a criminal, is achievable if it is prioritized. The long waits, where applicants are forced to wait an average of 281 days just to start processing, are precisely why the DOJ views this not as a mere operational failure, but as systematic obstruction. This lawsuit is a landmark achievement because it is the first affirmative lawsuit in support of gun owners filed by the U.S. Department of Justice. This action, taken by the Civil Rights Division under the Trump administration, marks a crucial, complete departure from previous administrations that have historically sought to infringe upon gun rights. The federal government is finally using its considerable legal power to fight for the rights of law-abiding individuals seeking to arm themselves. The legal basis for this unprecedented intervention is the Violent Crime Control and Law Enforcement Act of 1994. This act allows the Attorney General to sue local law enforcement agencies when they engage in a pattern or practice of conduct that deprives persons of constitutional rights. The DOJ is making the powerful argument that these administrative delays constitute a civil rights violation, equating bureaucratic delay with active systemic deprivation. Attorney General Pamela Bondi was unambiguous, stating, "Los Angeles County may not like that right, but the Constitution does not allow them to infringe upon it."
This action is also rooted in a critical public safety rationale. This conflict plays out against a backdrop of surging crime rates in major urban areas. Acting U.S. Attorney Bill Esseley was very clear. Citizens living in high-crime areas cannot afford to wait to protect themselves with firearms, while Los Angeles County dithers. The failure to process permits quickly leaves thousands of Angelenos defenseless, while assaults and carjackings surge. Harmeet Dhillon champions the position that expanded CCW access is crucial for community safety, emphasizing that, with violent crime in Los Angeles, I think the best offense is a good defense. A trained, armed citizenry is capable of interrupting serious crime and helping to save lives. The goal of this lawsuit is to seek declaratory relief, formally declaring that these excessive delays violate the Second Amendment, and a permanent injunction to prohibit the LASD from continuing to disregard the law on carry license issuance. This federal muscle sends an unavoidable signal to every single jurisdiction that still harbors recalcitrant attitudes toward post-Bruen compliance. While this lawsuit marks an incredible step toward accountability in California, we must zoom out to recognize that the LASD's conduct is merely a symptom of a much larger systemic infection that pervades the state. The problem stems from a political and legal culture that is hostile to the Second Amendment. California holds the dubious distinction of having more gun laws on the books than any other state, generating layers of restriction that complicate everything from purchasing, requiring a firearm safety certificate, to possession, including bans on assault weapons and limits on magazine capacity. The sheer scope of the infringement problem in Los Angeles County, home to over 10 million people, underscores how political resistance can crush constitutional rights. The deliberate foot-dragging forces applicants to wait so long that many simply give up, which is the entire point of the obstruction. The fact that law-abiding organizations, including the California Rifle and Pistol Association and the Gun Owners of America, were already pursuing separate litigation against the LASD, demonstrates the persistent, stubborn resistance of this jurisdiction.
However, chasing every bureaucratic loophole and staff shortage through endless litigation is a costly and exhausting strategy. The core issue remains the permit process itself. When obtaining a CCW permit is required, the government is granted too much power to add regulation, impose excessive fees, or simply ignore the process altogether. This is why the ultimate legal and philosophical goal must be the elimination of the permission structure entirely. The Speaker's ultimate recommendation, echoed by many pro-Second Amendment advocates, is that constitutional carry needs to be the law of the land. If Congress were to pass constitutional carry immediately, these specific types of administrative infringements, where local officials intentionally ignore processing deadlines and statutory requirements, would instantly cease to exist. While we commend the DOJ for this great start, the first affirmative action of its kind, the long-term security of the right to bear arms requires removing the gatekeepers who mistakenly believe they can turn a constitutional right into a manageable privilege. We must continue to push for these lawsuits up and down California and many other states, but true freedom is achieved when permission is no longer necessary. This historic lawsuit against the LASD proves beyond a shadow of a doubt that bureaucratic delay is a political weapon used to disarm law-abiding citizens. The federal government, through the DOJ Civil Rights Division, has rightly recognized that the Second Amendment must be aggressively protected from administrators attempting to starve it through unconscionable delays. This is a massive victory for constitutional enforcement and accountability. We must support the ongoing efforts to secure the permanent injunction that this situation demands. The message is simple. The government is tasked with upholding our fundamental rights, not deliberately obstructing them. And today, that message is ringing loud and clear in Los Angeles.